Good morning, Mr. Diller.
Good morning. May it please the Court, my name is Mark Diller. My colleague Ian Julia and I, we represent Charles Lev, the appellant here, an innocent pedestrian seriously injured by a drunk driver and repeat offender, John Ahern. 8 minutes before the collision, Ahern concluded an important one-on-one business meeting at a bar convened by an...
What about the fact that there was a written policy which said that people should not drink at business meetings?
Of course. Well...
Do we ignore that?
No, it's relevant to the case in a few different reasons. One is specifically that Ms. Passetti was violating that very same policy when she was drinking at the bar, and Beverly, as an entity, fired her for her violation of that very policy while drinking on the job at that business meeting.
Well, that may surely be a good thing or a bad thing, but how does it make them liable? How does it create a duty to third persons, this policy?
It doesn't independently on its own create a duty. What it does is it vests Ms. Passetti with actual authority under the circumstances to control the individual, her employee, while in the scope of that business meeting at the bar while they are violating the company policy. It also is evidence of the negligent act, whereas she created the circumstances herself.
Well, let me ask you this. Tonight, maybe not tonight, maybe Thursday night, there'll be 10,000 people that will leave work. They will meet with their supervisor for a drink after work to talk about maybe what's on the schedule for next week, what's going on tomorrow. They'll go to a local restaurant, maybe. Maybe they'll have a drink, maybe not. Or maybe they'll have several drinks. You're suggesting that such acts make the corporation responsible, in other words, create a duty to third parties that this employee might then injure on the way home.
Not in every circumstance. In our circumstance, yes, because this was specifically a business meeting scheduled.
These are all business meetings in the sense that we'll meet to talk business. Why don't we talk about that after work? We'll meet at the lounge downstairs and have a drink, and we'll discuss it.
Well, then the question will be...
And that becomes a business meeting in which the company now is liable to third parties?
If they encourage the consumption of alcohol on the job and then fail to prevent the foreseeable harm when they have within their actual authority the duty and the responsibility to control it and to prevent it, yes, then the duty arises and the breach therein.
Well, also, this just wasn't, let's get downstairs and have a drink and we'll talk about it. Didn't she come to the meeting with folders to discuss the specific issues?
She arranged the meeting. She scheduled it at a bar for a twice-convicted drunk driving offender. She went ahead and showed up with the documents. They could not complete these tasks during the normal business week because the head chef was on vacation and Ahern was filling in as a temporary management agent at the time.
So it wasn't just like going downstairs and we'll talk about it over a drink?
No, this was an arranged meeting because there was an important Department of Public Health survey that was forthcoming, and they needed to complete these tasks imminently.
Well, does it matter whether they brought files or not? If the purpose of the meeting was to discuss something at work, why does it matter whether they brought files?
Well, if scope of employment applies to the factual situation, then I suppose it doesn't really matter what the nature of the discussion is, but it is important as to the role of the parties when they're in that meeting and what direction they play.
The company didn't buy any drinks at this.
So
the company didn't buy any drinks.
Well,
to give the answer you gave to Justice Cordy, that if those things are true, don't you really have to say, what I'm asking you, Court, to do is adopt the dissent in the Kelly versus Avon Cape?
No.
What's different then?
Well, what's different here is that there is they created the duty in our situation. They actually scheduled the meeting at a bar. There's an affirmative act by the employer in our case. In the Kelly case, it was more of a passive act, watching an employee who supplied his own beer in a refrigerator that was not intended for any specific purpose, and they may have watched or seen him intoxicated, and they let him walk off the premises. In our case, we have a supervisor who is sitting across the table, is observing the employee consume alcohol contrary to company policy. They're watching him become intoxicated, and they watch him get up with the keys in his hand, knowing full well that he intends to drive 45 minutes home.
Is there evidence in the record as to whether the supervisor was on notice that he had a drinking problem?
Yes.
It seemed to me unclear from.
There's a lot of reasonable inferences that should go to a jury. We're at the summary judgment stage, and all reasonable inferences should be decided by the jury. And it's our position here that there is substantial evidence based on a 25-year relationship between the two parties, the fact that all convictions occurred while he was in his tenure at the company, the fact that...
Was he out of work for a couple of weeks because of one of them? That's what I
He was
didn't
2 weeks
clear.
inpatient. He lost his license for a year and a month, and during that period of time, he had to receive rides from his friends and family to and from work 45 minutes each way every day and was regularly late.
I'm sorry, how long ago was this prior to?
89 was the most recent, and that
Okay, so about 20 years?
About
20 years?
15.
15 to 20 years, okay.
Yeah. And there was only a 6-person kitchen. So they work in close proximity to each other, and she's known him and worked closely with him for 25 years. On top of that, they have a separate independent social relationship, which they go out regularly to the bar and they confide in each other on personal matters. In this situation, she's wearing the hat of employer, which means that all of her knowledge that she may have acquired during the scope of her personal dealings with him should be imputed to the employer at this time when she's in the scope of her employment. And clearly, she had a duty of reasonable care to prevent this foreseeable harm.
Let's go back to Kelly versus Avon tape again. And let us imagine that what happened here was not that they went to South Pacific, whatever it was, but that they said, listen, we have some beers in the fridge, we'll just go to a back conference room and we'll talk.
Sure.
Beers purchased by the individual, not by the company. Under Avon tape, if Ms. Pacelli had seen that he appeared to be a bit tipsy, would there be liability under Kelly?
Well, whether it takes place out of the office or at an outside business meeting, I don't think is necessarily the relevant factor. But it's important to understand in the Kelly case, the plaintiff in that case pled social host liability only. They did not ask for a negligence standard. And recently, just prior to that decision coming down, was the Moscow decision, which had codified or drawn up the elements of the employer host liability, because the employer host liability says when you're not in the scope of employment, you don't have any more control over your employees than a host has over his guests. So they didn't impose the same negligence standard that we're asking here. When the plaintiff pled in the Kelly case, he pled specifically the employer host standard. And on 3 separate occasions, the Kelly majority pointed out that they're deciding this case based on the employer host liability standard that was pled by the plaintiff. So
you're saying that the obligation of an employer depends upon whether the plaintiff claims social host liability or simply negligence?
Well, if you're applying, social host liability requires furnishing of the alcohol. In the Kelly case, they stipulated that there was no furnishing of the alcohol. If you were to apply the social host construct, that would be a relevant area of inquiry. But in our case, what we're talking about is knowledge of the employee, control over the circumstances, and facilitating and encouraging the consumption of alcohol. And in your fact pattern, I believe that there is enough encouragement, and the question then is if they had actual authority to prevent that foreseeable harm, knew that that foreseeable harm was imminent, then they had a duty to at least make reasonable approaches to preventing it.
Mr. Dilla, I understand. I'm sorry, Justice Gans, go ahead.
Well, I guess the problem is right now there's a relatively clear line, which is who controls the alcohol and therefore can pull away the alcohol. If we do what you ask, that line goes away. And what is the new line? Can you control the employee?
Control of the alcohol would still apply in situations where the scope of employment doesn't directly compel an employer to act with authority to prevent foreseeable harms that they
What's
haven't.
the line now? Control over the employee? Is that what you're saying the line is now?
In our case, or?
In your case?
Yeah, what we're saying is that there's actual vested authority to control the employee in the scope of employment and based on the policy that's at issue in this case, that Ms. Bassetti had actual authority to discipline or prevent John Ahern from consuming alcohol on the job while in the scope of employment.
So let's look pragmatically. Let's assume that your rule is in place and they're at the bar. Ms. Bassetti comes and Ahern's already drinking. What pragmatically is she supposed to do to prevent her employer from being liable?
Well, we're not asking for too great a burden. I mean, if in fact she decides that alcohol is going to be a very relevant part of the business meeting, then all we're asking is that she contemplate alternatives and reasonable alternatives. And in this case, Ms. Bassetti...
Like what? Like what? I mean, what precisely is she supposed to
In
do
our
to avoid
case,
liability?
the Beverly facility was only 5 miles down the road, and she even indicates that it was within her power to drive him back to the facility and put him up in a room for the night till the next morning, or at minimum, arrange for alternative transportation for him.
Mr. Dillard, it seems to me if you don't want to get put in the position of saying you're really adopting the Kelly dissent, that you have to prevail and to get us to carve out a different line is to say where the company policy gives explicit, contains an explicit prohibition against on-site drinking and then off-site to some extent, and she had the authority to enforce that policy in those circumstances. It's not just if you could just go to control of the employee, then you're right into the Kelly dissent, because the Kelly dissent is during the working hours. Well, you can argue that this was working hours, as has been interpreted in other lines of cases. Knew or reasonably should have known was intoxicated. Well, you'll say that's a jury question. Knew that the employee was going to operate a vehicle, that's the case here, and could have but did not take reasonable steps to prevent the employee from operating the motor vehicle. So it seems to me the Kelly case is simply saying if it's, within a working environment, obviously this court didn't adopt that. It seems to me what's different here potentially is that you've got a policy.
That is a significant difference. The other difference is that the supervisor was sitting straight across the table from him, engaging in the very same activity that the employee was during the scope of this meeting, and was encouraging and directing the consumption of alcohol here. So they made an affirmative decision, an affirmative action to actually help create the harm. Now all we're asking them to do is, if you're going to create this harmful situation and facilitate the employee's intoxication and leaving the business...
I'm really sorry. You keep saying facilitating the employee's intoxication. Where does that come from?
Well, there's a couple things in the record. For starters, when he arrived first, Ahern arrived first at the meeting.
He stops 3 nights a week on his way home. This is, I'm not quite sure what you're getting at.
But the facts in the light most favorable for summary judgment indicate that she arranged this meeting after hours.
I'll meet you at the bar.
Right. And
where
so,
we both stop.
Well, she said specifically, we're going to arrange to have this meeting at the bar. She arrives. He's expecting her. She's instructed him in advance to order her a drink. There's a specific drink that's waiting for her, so she's virtually saying alcohol will be permissible during this business meeting.
That's the basis of your statement that she is not only facilitating but encouraging him to drink alcohol.
She drinks with him, and then they order another drink at the bar, and they share that drink together. So it's far more than just observing somebody else breaching the policy. She's engaging in that same behavior and encouraging it, and for all intents and purposes suggesting that the rules don't apply per se, even though this is business meeting and we have to conduct important business.
There's a problem, though, is there not, in relying, I would think a sort of policy problem of putting all your eggs in the policy, that is, no drinking on the premises, because clearly you don't want a rule that is going to encourage, that is going to discourage businesses from having policies against drinking on the job.
Of course not. and we don't seem to impose that type of burden. We're saying look at the totality of the circumstances in this case. She's created that harmful circumstance, and she has not just the control that's been established by our common law, but she has actual control that's vested to her in the policy. And all we're suggesting is that she make reasonable acts in order to try to prevent that foreseeable harm, because it should have come as no surprise he would drive 2 miles down the road after leaving the bar, run over the pedestrian, and result in his third conviction for DUI. So,
Thank you, Mr. Diller.
thank you very much.
Mr. Desmond?
May it please the court, my name is Joseph Desmond, and I represent the appellee, Beverly Enterprises, Massachusetts, and David Viennes is with me. I would like to address, I was going to address something else first, but the issue here is policy, because the Kelly case and the Moscow case address the legal duty. And setting aside the factual discrepancies in this case, as I think we may, because the first question in every negligence case is one of duty. And this court has made the pronouncement that an employer shares the same duty as a social host when it comes to alcohol consumption of its employees. And that is, if there is no control of the liquor supply, there is simply no duty. The other facts are not relevant because of the threshold inquiry that there is no duty.
But here, the employer had a policy that said no booze.
Correct. And if I may address that, Your Honor, a policy is not there to establish a legal duty. Policies may be used once a duty exists to determine the second element of the tort, which is whether there was a breach of the standard of care. And the most prominent time in which a policy is used perhaps may be a medical malpractice case, where there certainly is for every neurosurgeon the obligation to the patient to act as a reasonably prudent neurosurgeon. Well, we as lay people don't know what the standard is for a reasonably prudent neurosurgeon, but there's no doubt he's got a duty. We can then look to the policies of those experts and other neurosurgeons who say, here's what we do in the case of a brain hemorrhage. Here are the things we have to take a look at. So I would respectfully suggest, Your Honor, that the policy is evidence of the standard of care that must be met after a legal duty is established. And this court has said in both Kelly and in Moscow that there is no duty, period, end of story.
What if the meeting here were on the business premises?
Again, Kelly says it doesn't make a
change them.
difference. And I would also like to point out another very important part of the policy argument, the written policy. My brother would have this court adopt a position that the policy confers some authority. That is wrong. Every employer in an employment at will situation has the authority to fire, to retain, to suspend, to discipline its employees by virtue of basic master-servant principles established at common law. The principal has the right to control the actions of the agent by virtue of the master-servant relationship. The agent serves at the will of the master. Whether or not there is a written policy is superfluous, and I would suggest, as I think some of the justices have observed, that the written policy should serve to discourage employees, and what it says to them is, hey, if you are drinking on the job, you're out of here. And this policy is in the setting of a nursing home, a licensed nursing home, and the purpose of the policy, obviously, is to protect its patients. It has a duty to protect its patients. And we don't want any employees consuming alcohol while they're on the job, because that would impact the quality of care, and that's specifically in the written policy as the purpose of the policy. It certainly is not to adopt some principle that because some employee, again, after work, and in this case, the undisputed facts are that Mr. Ahern had punched out of work. He was a chef employed as a nursing home chef. And I understand there's a meeting that, again, as I think Justice Cordy pointed out, they were talking about business, and she may have some menus asking about what was going on in the Department of Public Health survey. But if we look to Moscow, the last paragraph of the Moscow decision, and I think it's ignored by even the appeals court, there's a conjunctive, the word and that is that it's motivated by the purpose to serve the employer, and, which is what we've overlooked here, that it's within the time and space boundaries for which the agent was hired to perform. Mr. Ahern is a chef. He is not
Yeah,
hired.
but this was a business meeting.
Well, even Mrs. Pacitti, who is in the light most favorable of the plaintiff, says, I brought some menus and we got some productive, she
Oh, she
says we were
got-
on our own time.
Well, she got fired for it, is that right?
That's not correct. There were two reasons given for her termination. One was alcohol policy, the second was falsification of her time card. And the employer couldn't tell which it was,
All right,
because she's,
but in
again,
any event, if you look at it in the light most favorable to the plaintiff, there is some evidence that this was a prearranged meeting by her to discuss business for the next week. Is that not so?
I mean, I don't think that's the case. I think there's a line in her, she said when she was leaving, I think as Justice Cordy has suggested, I'll see you down at the restaurant where they had been 3 times a week. That's as close to prearranged. She does not say that we prearranged a meeting so that we could discuss the policy or the upcoming Department of Public Health survey. That's not what she says. And setting aside that, again, the factual discrepancy, the question of legal duty makes no difference whether or not she said, yes, I'll see you down there, and we're specifically going to discuss the Department of Public Health survey. And furthermore, you have to be there. It doesn't matter, because Moscow and Kelly affirmatively established that had it been on site and she said, I'll see you down in my office in 10 minutes, we're going to discuss the Department of Public Health survey, and he brings a 6-pack of beer and gets intoxicated, the employer is not responsible.
Mr. Desmond, could you discuss Justice McHugh's theory of respondeat superior and why we shouldn't go down that road? I mean, he deals with negligence as a separate issue.
Right. I think Justice Greeny's decision in Moscow squarely addresses it, and specifically addresses the same arguments that are in the brief here today, and that is the plaintiff appellant asked this court to adopt the restatement sections 315 and 317. Any adoption of that would be a specific deviation from the exact holding in Moscow in which that was addressed. Justice Greeny said that to suggest that the employee on the way home after getting intoxicated, and this, in Moscow, the employee, I think, was a salesman, to suggest some exception to the comings and goings rule in that case defied logic and defied the facts of that case, and that's at the end of that decision. So again, that's raised in the Moscow case, rejected by the Moscow court.
Why is the supervisor a social host?
I'm sorry?
Why is the woman a social host?
I don't think she is a social host. I think, if you...
Our case law has made the social host doctrine applicable
Right.
to employers.
In Moscow, the court questioned, should there be a separate standard for an employer versus a social host when the function is consumption of alcohol? And that question was answered affirmatively, no. It's just not. We have one standard, that is a social host or the employer when alcohol is involved.
I may have misunderstood Justice McHugh's dissent. I thought, following up on the Chief Justice Marshall's question, was that he said we should focus on the supervisor and whether she was negligent and whether, through the doctrine of respondeat superior, the corporation should be negligent. Is that different?
No,
Isn't that...
he first dealt with respondeat superior and then turned to negligence and got to the as I read the dissent. He goes through the respondeat superior stuff and then goes to as for negligence and then goes on to control of the supervisor.
Again,
he may be mixed. It's hard to say if it's not how he would describe the duty, right?
Yeah, all due respect to the dissenting opinion, it seems to me that those issues are all resolved by Kelly and Moscow in that whether we focus on the supervisor's conduct, again, she's not controlling the alcohol supply.
No, but what Justice McHugh is suggesting is as to that, instead of having a control of alcohol, you could have a control of employee.
Right, but by virtue of the principles of principal agency, the employer, Raytheon, controlled the behavior of the salesman that attended the Christmas party in Moscow, and Avon Tape controlled
No, I understand.
behavior on the job that day. And the employee, they stipulated for the purposes of that argument that he was intoxicated on the job, on the clock, on the premises. And the court still answered the question that there is no duty.
I'd just like to go back to something you said earlier. we said that the policy is only relevant as evidence of the standard of care, but it doesn't create a duty.
Correct.
I have a little trouble with what you're saying, but more importantly, and I think to the point that you were trying to make, what is the purpose of the policy, of the no drink policy in this case?
It's to protect patients in the nursing home.
Okay, and the person who was injured was not a patient in the nursing home?
No, he was a traveler who was crossing the highway after Mr. Ahern and Mr. Lev were in the bar for an hour and a half or so. They consumed their alcohol at the South Pacific Chinese restaurant.
So I take it that I mean, at least if it's possible that a policy can in fact establish a duty or a standard of care, it's with respect to patients in the nursing home. And that policy here should only be construed in terms of the corporation's relationship to the patients in the nursing home.
I disagree, and if I may,
Yeah.
the duty exists. That's a nursing
Well,
home.
that's a separate duty.
Right, they've got a duty of reasonable care. The question then becomes, what is a reasonable duty? Now, if this chef had become intoxicated and in the course and scope of his employment, spiked the soup with something that was detrimental to the employees, or he was under the influence, I think it's certainly relevant to establish a breach of the standard of reasonable care to the patients, to use that policy to say that, your internal policy says that your employees shouldn't be intoxicated while providing patient care.
But your point is the duty independently exists to the
Correct.
patients.
Yeah.
It has to exist first.
In here, the policy really sheds no light on the. It doesn't create a duty vis-a-vis third people, and in any event. But to the extent that it's evidence of anything, it's only evidence of a breach of a duty between the corporation's
Correct.
employees and the patients at the nursing home.
Yes, and if I may, on the issue of does a policy create a duty, this court recently ruled in Levitt versus Brockton Hospital in a case in which there was a hospital policy that stated that hospital or patients who are under narcotic treatment should be escorted from the premises. And this patient left the premises and in a car, and I think struck a police officer. And in that case, the plaintiff said that, well, this existence of the policy creates a duty to the third party. And this court ruled, just as I'm suggesting here, that the duty of medical malpractice or duty of reasonable care exists to the patient, but not to the third parties.
With respect to the sort of going and comings rule, aren't there occasions when we've said that, if an employee has to travel someplace for a business meeting, that going home from that business meeting may be within his scope of his employment?
There are cases that have said that, but I think Moscow is square on that as well, and that it was a company-sponsored event where the court acknowledged that a benefit was conferred upon the employee, however nominal, and the salesman, again, was driving home, and Justice Greeny's opinion addresses it by suggesting that, because the comings and goings rule was at play in that case as well, in which this court said that we're not going to make the exception or read into it that there was some liability under the comings and goings rule. Again, looking at the specific employee, and if we look at this employee, we've got a chef whose job is to cook food in a nursing home.
But if he'd been told to go to Worcester, there's going to be a big planning meeting concerning whatever it was. There are several chefs from around our different places. They're meeting with some other people in Worcester. You need to go there tonight and participate. And it was at a restaurant, and he was drinking, and then he has to drive 60 or 70 miles home, not something he would ordinarily do. I mean, no liability there?
I haven't considered it, Judge.
I mean, we're just talking down the street, but what if it's 60 miles away, someplace very far away that he's been directed to go to for a business meeting? That make a difference?
Again, I think if he's supplied with alcohol under those circumstances, the case may be different.
Well, no, it's at a restaurant, so people are drinking. All right.
Well,
What's the purpose of the policy if the business meeting occurs someplace outside the nursing home where there are no patients? I mean, I thought that the policy was to make sure that the patients were not.
right, and if there's a business meeting about in the nursing home context, they're making decisions that affect patient care. That is, should we have a policy, and what should the standard be with respect to whether we should admit demented patients? We want sober people to make those decisions. as opposed to people that are intoxicated. While there isn't direct patient care, it all goes ultimately to providing patient care.
Thank you, Mr. Desmond.
Thank you.